morning. People versus Joy Ellen Sensky. This is file 21-1692 SD2. It's the date and time of sentencing. Conviction here is operating while visibly impaired. So Ms. Sensky's here via Zoom. Her attorney, Mr. Graff, is here via Zoom. Let's see. Ms. Sensky, have you had the chance to review the no PSI ordered cover sheet and the substance use assessment with Mr. Graff? Yeah.
I have, yes.
Are these documents, are they factually accurate, or are there changes, corrections, or additions you'd like to have made?
There were some changes that I discussed with Jake. I don't know if he wants to go over them, if you want to go, or if you want me to go over them, whichever you prefer.
Well, how about if we
I can bring it up.
Yeah, go ahead, please.
Thank you, Your Honor. Good morning. We went through the documents. They appear accurate. The only real issue we had was under the drug alcohol use portion of the assessment.
Okay.
Midway through that paragraph, it reads, Ms. Sensky acknowledges drinking on a few occasions since her arrest. That is true. And failing PBTs the following morning. That is not accurate. She identifies her last use as November 2. We believe that is approximate. But the portion about failing PBTs is not accurate.
Okay. Yeah, when I saw that, I looked back at testing results, and there have been no issues while on bond with regard to testing. Okay. Do you have another change or correction, Mr. Graff?
I don't believe so, Your Honor, and that the documents appear accurate.
Okay, very good. Then by way of elocution, Mr. Graff, do you have comments you'd like to make?
Yes, please, Your Honor. Your Honor, I think we'd be having a completely different type of conversation today if Ms. Sensky wasn't brutally honest during the assessment. I think we take a look at the cover sheet for the no PSI. It talks about how she's been compliant and has been passing all her PBTs. But she was blunt and frank in her assessment. I think she gave a really good idea of what she was up to that night. Rather than just saying I had a few drinks, she identified the different stops she made, the number of drinks she had. She also disclosed a prior incident back in 2009 for reckless driving and acknowledged alcohol was a part of that. And so I think this is somebody who's taking this very seriously. I know the court may have questions given the fact that she's been consuming alcohol while on bond, but again, if she didn't self-disclose that, we wouldn't be having this type of conversation. And obviously that's the first part, is if someone is going to acknowledge their wrongdoing and try to make things right, is they're going to be honest throughout the proceedings. And she thought that it was necessary in order to disclose that to the assessor, because the assessment means nothing unless someone is candid in it. And so I don't want to see her be punished for being candid. Again, if she didn't disclose this, we wouldn't be having a conversation about drinking on bond and what may happen as a result of this. I think the court would be impressed with the fact that I think it's noted that she's an e-commerce manager at Leonel Sellers. I think she's been there for a number of years and a valued employee. She's got a college education from the University of Utah. She has a degree in psychology. And as I understand things, she's a classically trained musician. And so she has a lot of skills, a lot of talents. It's just unfortunate that we find ourselves here before the court today. I typically, without those disclosures, if I didn't know about those, I think we would be talking about maybe a fines and costs type of sentence with a short term to make sure that she complied with the alcohol highway safety class victim impact panel. I understand with the concerns about consuming alcohol while on bond, a short probationary period would be appropriate in order to make sure that Ms. Sensky is refraining from the use of alcohol, as well as she completes the highway safety class and victim impact panel, and also to make sure there aren't any other issues that haven't been disclosed. But again, Your Honor, I think this is somebody that, although the court may has reservations because of the drinking while on bond and this being a drinking and driving offense, again, I think that this is the rare occasion where, being honest, it shouldn't, I guess, come back and bite her. Obviously, she could have lied throughout the entire process, and we'd be having a different conversation. And so I asked the court to consider placing Ms. Sensky on a short term of probation, allow her to demonstrate to the court that she can comply and not consume alcohol, that she will get the highway safety class and victim impact panel done. And I would expect that now, knowing the potential consequences of what her behaviors could result in, I don't see Ms. Sensky continuing to drink while on bond. And I think that the court has her attention, and I think she can be successful on probation.
Okay, thank you, Mr. Graff. Ms. Sensky, are there comments you'd like to make?
No, Your Honor.
Well, in reviewing the assessment, I too believe that Ms. Sensky was very honest and open, and that resulted in, I think, a very good assessment and recommendation. So we don't all the time see that kind of situation, so I appreciate her honesty here. So the assessment does conclude that there is a mild use disorder and recommends the alcohol highway safety education class and the victims impact panel. I do think that's appropriate. But let me ask Ms. Sensky, in terms of the drinking on bond, could you explain what that was?
So I work at a winery, and it was early on in this process. We had a wine tasting at lunch, and I wasn't ready to disclose why I couldn't partake and participate in something that is almost required by my job. So I did have 3 sips of wine at that wine tasting. I didn't sleep very well that night. I had very high anxiety because of the test the next morning. So that was one situation. I had another situation where I was out with a very long-term friend that I wasn't ready to disclose this information to as well. I enjoy whiskey. He had a very delicious whiskey that he kept offering me. I wasn't ready to have the conversation, so I had a couple sips. Also, same thing, very high anxiety associated with that. So it's not something that I want to move forward with. So those were 2 isolated incidents that, although not totally justified at the time, felt almost necessary, but.
Okay, well, I appreciate your honesty with respect to that issue as well. Let's see, Mr. Chamberlain, any comments from the people?
Your Honor, I think it's rare and shows that Ms. Sensky has a lot of integrity in order to disclose these things, whereas I just don't see that very often. So I think Mr. Graff's recommendation is appropriate, Your Honor.
I agree with all comments that have been made this morning. So what we'll do is place you on a 4-month probation, Ms. Sensky, and at the halfway point, which is 2 months, you can request early release if everything is going well, and I think everything will be going well. There's a $100 fine, $400 court costs, $75 crime victims fee, $50 state fee, $125 arrest fee. Now, while on probation, you may not use or possess alcohol, illegal drugs, controlled substances that you don't have a script for, no mood or mind altering substances, no recreational marijuana. We'll continue the daily AM PBTs plus the discretionary drug screens. No bars, casinos, or places that serve alcohol by the glass except for work purposes, but just can't consume at work, okay? I'll order as recommended in the assessment, the alcohol highway safety education class and the victims impact panel. Let's see, 2 days community service work, not to act in a violent, threatening, intimidating, harassing way toward anyone, be respectful of all court employees, service and care providers, credit for time served, and if you have any contact with law enforcement, you need to let probation know about that. So it's a pretty straightforward sentence. Again, you can turn it into a 2-month probation, ma'am, if you do well. So we're all set. Do you have any questions, Ms. Sensky?
No, sir.
Okay. All right. So feel free to leave the proceedings if you like. Thank you. Thanks, Mr. Graff, Mr. Chamberlain.
Thank you, Your Honor. Before Ms. Sensky leaves, should she contact probation today or wait till Monday?
Today will be fine. Do you still have the phone number for probation, Ms. Sensky?
Let me get it. Let me get it just in case.
Sure. Okay. It's 922-6899.
922-6899.
Correct. So call
Okay.
between 1 and 3. Yeah, call between 1 and 3 today, please. They'll schedule you for a short phone interview with your probation agent to discuss these terms. So you're all set. Yep. Thank you. Good luck going forward.
Thank
you,
you.
Honor.
Thank you. All right, we can call the next case this morning. People versus Charles Robert Cannon. This is file 21-1690 SD2. So Mr. Travis is here by Zoom as Mr. Cannon's lawyer. Well, the only person that could be Mr. Cannon is an electronic device called a TCL A3, but it's not connected to audio. Mr. Travis, do you know if that is Mr. Cannon?
Your Honor, I don't. I could try giving him a call here.
Okay.
I believe I've got his number like right here, so I will see.
Okay.
Your Honor, I do believe that was Mr. Cannon. He's going to try and either reconnect or find the way to connect to audio.
Okay. All right, that sounds good. Thank you. What we could do is call the case of People versus Christopher Lee Reuters, file 21-1666 SD2. Mr. Reuters is here by Zoom. His attorney, Mr. Razvi, is here by Zoom. Let's see, Mr. Reuters, could you unmute, please, so we can hear you?
Did that work?
That works. Okay, thank you. Okay, so today's the date and time of a scheduled guilty plea. The plea offer from the prosecutor is operating while intoxicated first, a 93-day misdemeanor, Mr. Reuters. In exchange, operating while intoxicated second, a 1-year misdemeanor would be dismissed. So do you wish to accept that offer, Mr. Reuters, and plead guilty?
Yes, I believe that's the agreement between me and my attorney. I haven't heard from him today.
So Chris,
Well,
I'm
Mr.
right
Razvi's-
here. And again, that's the plea offer that was offered to you. You had previously tried to get into sobriety court. That's why this has been delayed. That's not a viable option. Do you want to proceed with a guilty plea to the deal of reducing it from a 1 year down to a 93-day first offense?
Yes.
Okay. All right. Mr. Reuters, are you on any probation or parole?
I'm on probation out of Benzie County.
What for?
OWI.
First offense?
Yes. May 24th of like a year and a half ago, whatever it was.
2020. All right. Okay. So this would be a violation of that probation, a conviction for another operating while intoxicated. So in Benzie County, if your probation agent chose to violate your probation, you could be resentenced to up to 93 days in jail in Benzie County. Do you understand that?
Yes.
Are you on any other probations or paroles anywhere, sir?
No, sir.
Okay. Other than this plea reduction offered by the prosecutor, Has anything else been promised to you, or have you been forced, threatened, coerced, or had anything done to you to make you plead guilty against your will?
No.
So it's your own free choice to plead guilty, right?
Yes.
Have you discussed all of your rights to trial with Mr. Razovich, sir?
Yes.
Do you understand that by pleading guilty, you're giving up all your trial rights and you won't have a trial of any kind? Do you understand that?
Yes.
All right. You understand there's a driver's license sanction from the Secretary of State because of this conviction, right?
Yes.
Okay. Was Mr. Razovich appointed to represent you in this case, sir?
Yes.
Okay. All right. So the information here states on or about August 30, 2021, Leelanau County on East Traverse Highway, that you're operating a motor vehicle. Is that correct?
Yes.
Were you pulled over by the police, or was there an accident of some sort?
I was pulled over in the process that I was attempting to pull over. A deputy happened to be parked where I was trying to pull over. I had a ride en route to come pick me up because I didn't feel comfortable driving. And so I was pulling over and a deputy was in my way. So I tried to go around him and then he pulled me over as a result.
Where was that?
In Leelanau County, off of 72.
All right. What was this, a parking lot or just the side of M72?
It was just a random spot off of 72, just maybe 3 minutes away from the residence that I had just previously left.
I see.
As I said, I didn't feel like I was intoxicated or to any buzz standard, even when I
Right.
left the residence. And about 3 minutes after I left the house, I changed my mind. I didn't feel comfortable anymore, and so I pulled over. I had my friends on their way to come get me, and in the
Yeah.
process of pulling over, a deputy happened to be parked there. I'm assuming he was doing a speed trap or whatever it was, and
Okay.
I swerved back over to my lane to pull over later, I guess. And just as I passed him, he pulled me over.
Okay. And then he suspected you might be intoxicated, ran you through sobriety tests.
Yes.
You were arrested, and you were taken to the Leelanau County Jail where you had the data master breath test. Is all that correct?
Yes.
All right. And I don't have the data master results. Do you recall what those were, Mr. Roders?
0.12, Your Honor.
Okay. Okay, 2.12s. Do you have any dispute with those data master results, Mr. Roders?
Only things that I don't think would be relevant just because I felt like I had done the right thing by calling for help when I felt like that I was reaching a buzz. And
Chris, we'll talk about that at sentencing. You have no dispute to those results. Those results are accurate.
all right, no dispute then.
Okay, thank you. So we'll accept the plea to the added count of operating while intoxicated first. We'll dismiss the original charge. We'll refer this to probation for pre-sentence investigation, sentencing recommendation, substance use assessment, continue the bond, sentencing, and will be, yes?
Just regarding bond, Mr. Reuters has been testing since August. He's done very well. He kind of lives, well, he lives pretty far out. He's trying to get the in-home unit. He can't financially afford it. At this point, with the plea being entered and sentencing on the horizon, I would ask that the court consider putting him on a random schedule so that he's not driving out every morning, and he's soon going to lose his driving privileges altogether. So I would just ask that you consider putting him on random testing.
Okay, so Mr. Reuters has been on bond since August 31st. I don't see any issues. And he's been testing every day. All right, Are you testing at the Leelanau County Jail, Mr. Roders?
No, at New Direction in Traverse City.
New direction. All right. Well, okay, that's quite a while of good bond performance. So I'll reduce the PBTs to 4 times monthly random at this point, okay?
All right, thank you, Your Honor.
Did we get the sentencing date?
January 7th at 9 a.m.
Thank you.
All right, so last thing, Mr. Roders, I have to give you probation's phone number and have you call them between 1 and 3 today. Can you write this number down, please?
Hold on a second. All right.
231-922-6899.
And I need to call them by when?
Well, between 1 and 3 p.m. today, that's probation. They'll schedule you for a phone interview with your probation agent to create a report for sentencing, and they'll tell you also how to get the assessment done. All right?
All right.
Okay, but you're all set for now, Mr. Roders. Feel free to leave the proceedings if you like. Thank you. Thank you, Mr. Raspberry and Mr.
Thank you,
Chamberlain.
Your Honor. If I may, on a separate matter,
Sure.
there is a probation violation hearing set for 10:45. I'm kind of jammed up at that time. I spoke to the individual. If he's able to log in, does the court have the availability to take his matter prior to 10:45? It's Jacob Hester.
Yes.
It won't be a hearing. It will just be a plea with allocution.
Sure, we can do that.
All right. Thank you, Your Honor. I'll give him a call.
All right, thank you.